This is Healthcare Now Radio's Interviews Now. Thank you for joining us. I'm Shereese Maynard, today's host. Follow our show with the hashtag InterviewsNOW and join the conversation. In this fast-paced, ever-changing landscape we call healthcare delivery, who can we trust to tell us, good or bad, what's happening now? Let us help you sort out these issues with today's thought leaders in the know. On this episode, we'll be discussing healthcare compliance with our guest, Matt Fisher, partner with the law firm of Merrick O'Connell. Matt himself is the chair of the firm's health law group and a member of the firm's business group. Matt focuses his practice on health law in all areas of corporate transactions. With regard to compliance matters, Matt advises clients to ensure that contracts, affiliation, and coordination agreements and other business arrangements meet both federal and state statutory and regulatory requirements. Matt's regulatory advice focuses on complying with the requirements of Stark Law, anti-kickback statute, fraud and abuse regulations, licensing requirements, HIPAA, the Medicare program, and the Sunshine Act. And I'm glad to have this opportunity to chat with him today. Hi, Matt. How are you?
Doing well, Shereese. How about you?
Pretty good, thank you. Now that spring has finally sprung, how are things in Massachusetts?
Well, just like usual with the weather here, it pretends like seasons have changed, but we still have the lingering hold of the previous one, and just got swung back and forth all the time.
I understand. So tell us, for our audience, Matt, tell us a little bit how you found yourself in the health IT space.
So kind of the health IT space, I think, was a little bit of an extension out of first doing healthcare law a little bit more generally. So it kind of started off focused a lot on the provider side of the world, and then that allowed me to really figure out what health law was, or at least the corporate and regulatory piece of health law, because it's health law as a whole is basically as broad as the law itself. But working with providers, learning some of the basics, some of those laws that you mentioned, the Stark Law, which is a civil law governing referral relationships, the anti-kickback statute, which is the criminal kind of corollary to the Stark Law, HIPAA, various licensing, and other regulatory schemes. So getting used to that, and then as I was doing that, I think the transition to health IT was actually spurred a lot through engagement on social media. Kind of finding an audience I guess audience is not the right word, but kind of finding a group to be able to interact with, which you are very much a part of, seeing what topics interested people, and that ended up being a focus on HIPAA, privacy and security issues, which I think aligns a lot with the health IT world. So once I started interacting with people and learning about what the issues were through, seeing comments or getting into dialogues with people on Twitter or LinkedIn, and then, using that as a means to get an introduction by phone or, seeing someone at a conference, when you see the issues and you can start commenting on it, then you're kind of like, oh, maybe I'd like to actually focus and work on this area too. So it's not just something I'm doing in free time or just for fun. If I can make the fun actually be a part of my work, I think that was a very good goal to be able to pursue. And that's kind of, as I said, the direction that I ended up going in. So I work with, so now I work with some of the people in health IT, but I also still work with providers. So it's a nice interaction. And, sometimes it even is be able to benefit those types of clients, because, if I'm working with a provider client, I can say, hey, I know about this solution. It might actually be a good fit for you, or vice versa, of, a technology company is looking to do something and be like, hey, have you talked to this group? So it kind of ends up with a nice synergy.
Yeah, I totally agree, because I still myself work directly with providers and also on the vendor side. So it brings up some interesting cross sections where you see something might fit well for one of your clients and that type of thing. And it's always a good thing when there's some synergy and things kind of work out in that way.
Yeah, no, and I also like they follow, I think, different but aligned business models. So you can kind of learn different directions of where things might be going in the industry. And, when you're in a position where you have the benefit of working with multiple different businesses, you end up kind of having a broader view of things. So, one of the things that I've always surprised about is, being a corporate lawyer, a lot of the clients that I work with, the advice or the assistance that I provide probably isn't what people think of as traditionally legal work, but it's definitely more of a blend of legal and business advice. And it's, kind of from one perspective, more the fact that, my understanding of the legal and regulatory landscape will help to color and influence some of the business suggestions that might be provided, since I can kind of see down the road a couple of steps and understand where a hurdle might be or where a barrier might be, so that, so you end up kind of altering the path ahead of time, so that way you can have a little bit smoother of a path in pursuing an idea or being able to get to an end goal.
Right. Well, that brings me to my next point. Your firm has quite the portfolio. I've been reading up on them quite a bit. And I was wondering, how long have they been in the healthcare sector? And what do you think has changed from the time they entered, or I guess you also entered healthcare law, and what we're seeing today?
Kind of as you said, my firm is a completely full service firm. I just happen to be the one who focuses on corporate and regulatory work in the healthcare space. But, as a whole, my firm does everything but criminal law. Very historically, we've always had clients in the healthcare space. It's just the fact that I started working on some of those clients when I started at the firm in 2008 and developed more of that regulatory expertise. So we kind of deepen the type of work that we were doing with those clients, which is more of that regulatory type assistance, as opposed to, maybe just an employment matter or labor issue or real estate. So now it's kind of enabled us to be a bit more full service with the particular clients. And, in that 10 plus year period now, I'm honestly not sure that from my perspective, too much has fundamentally changed. From the corporate perspective, there are, I've already mentioned them, the Stark Law, the Anti-Kickback Statute, and HIPAA are kind of the core three that run through and can potentially influence anything that any of the clients that I work with might want to do. Obviously there's been some modifications and changes in interpretation to those laws over that period of time, but nothing wholesale where anything has fundamentally changed.
As you say, people are still trying to figure out a lot of these laws and how to interpret them, which brings me to my next question for you. I myself write plans of correction, and I feel like I see some issues more than others. What type of legal challenges are you feeling are more prevalent among healthcare organizations?
To some degree, that depends on what area you want to focus on. I think an easy one to pick on is the HIPAA side of the world, which is, I think hopefully most people know, focuses, at least for purpose of what we'll talk about, focuses on the privacy and security and data breach notification. I always like to remind everyone that the biggest piece of HIPAA, which is, common transaction sets, I never actually have to talk about, because I don't worry about the actual submission of claims or that piece of the world. But that has a big impact, and actually there was recently some announced activity in terms of wanting to ensure that people are appropriately complying on that side of the HIPAA field. But when you're talking about kind of privacy and security issues, I think one of the issues is getting people to actually proactively and upfront address compliance requirements. Mm-hmm. The challenge, I think, can be especially pressing when you're looking at smaller practices, where definitely appreciate that resources can be constrained. Time is definitely, if anything is available, is not going to necessarily be devoted towards compliance, but is going to be thinking about how to help improve flow or other efficiencies in the practice. But I think examples definitely bear out that no entity is going to be too small when it comes to the potential for a breach, whether it's a failure of a security measure or some failure in terms of complying with privacy obligations, which honestly could be not responding to an individual's request for access in a timely manner, and not necessarily something where you're not respecting the privacy of the information that you're entrusted with. Kind of shifting to the other side, which is the fraud and abuse side, driven by Stark and anti-kickback. I think, to be fair, I don't think anyone, or at least thankfully the people that I've had the opportunity to work with, no one is actively trying to do something that is not going to be proper. I think some of the challenges that can come up with, and it kind of ties back to what I was talking about for the value-based care side of things, is that as new models and new means of setting up arrangements between different organizations are explored, they're not necessarily consistent with how the regulations think about the world. And some of the pieces of the regulations that do open the door to these arrangements don't necessarily have a lot of background explanation or guidance or commentary. So everyone's kind of feeling their way through the dark. So from that part of it, it kind of goes back to another thing that I said earlier, which is if you've got a client who wants to engage and discuss the issue and really work through it, it makes it a lot easier as opposed to just being presented with well, this is what we want to do. I always find, from the outside lawyer perspective, I like to work hand in hand with my clients and, really help to see the business vision. And then that way we can work collaboratively to figure out, what's the best way to tackle this issue. Because I don't want to be a barrier to a business goal. It's, I always like to tell people this is still true, I can count on one hand the number of times where I've just flat out said, no, this idea can't be done because I can't reconcile it with how the regulations operate. By making that statement still true, I then say, the path that we will follow to get to that end goal is definitely not going to be the same direct one that you might have envisioned up front. We're going to zig and zag quite a bit, but we will get there at the end of the day. It just takes a commitment to being open about the goals behind each idea and how it's going to kind of how the sausage gets made behind the scenes. Because when you're talking about fraud and abuse, you always have to remember, while a lot of stuff in healthcare, especially when you're talking about providers, probably honestly does come down to how can we get patients to come back and forth. You really shouldn't be trying to use that as the focal point for determining any type of exchange of money or other benefits. And you want to be looking at, is the arrangement going to make sense even without that? Because the laws do have a negative view of pushing patients back and forth so services can be billed.
Right. And I know with a lot of providers, they lean towards intent. Like you were saying, it's not like they're intentionally trying to do something wrong. So when you explain a situation, or if your clients have fraud issues and that type of thing, do you take time to educate them on what Stark actually is or what HIPAA actually is and that type of thing?
Yes, no, I think people can't comply with something if they don't understand it.
Right.
So, I think education is a key part of whatever you're trying to do. When I've been working with clients longer term, obviously I don't have to go into it every time. It's, sometimes people lead off with, well, is this going to be a problem because of X, Y, or Z, which I think means that they are now thinking ahead and trying to identify the issues and trying to make sure that something is set up the right way. I think especially working with somebody for the first time, sometime, if there isn't necessarily the same degree of experience, then, walking through and trying to explain what are frankly very dense and opaque laws in a way that can be understood more readily, I think is really kind of a very important function of what I can bring to the table. Because I always like to tell people that, when I'm working on an agreement or if I'm working on a project, if I set something up so only I understand it, then I haven't served the client very well.
Mm-hmm.
Then you haven't really done, or you haven't really implemented or executed a business idea that will be sustainable and successful in the long run.
Exactly. If you're just tuning in, you're listening to Interviews Now on Healthcare Now Radio. And I'm talking to Matt Fisher about healthcare compliance. Okay, so Matt, last summer, CMS solicited input on potential amendments to Stark. Now it looks like we're probably going to see some changes this year. Some people say we don't need them, others have different opinions. But what are your thoughts about the evolution of Stark?
Yeah, it will definitely be interesting to see what CMS actually puts forth. I'm very hopeful that they are taking the comments seriously, and certainly they've been putting on, or individuals from within CMS and HHS have been putting on a blitz of appearances at conferences and in other places of saying that changes are coming and that they're going to help move the ball to be more in line with a value-based care delivery system, or I guess value-based care delivery and reimbursement system is probably a more accurate way to say it. I think I was saying before, even under the current scheme and the way Stark and obviously anti-kickback, which was a separate solicitation, not through CMS but through HHS. Even though you can fit value-based care models into the current regulatory scheme, you do want to see some changes to make it a little bit more recognized that when you're talking value-based care, you're really talking about care coordination, sharing of benefits, and a more transparent and direct flow of money in between these disparate entities. So anything that can be done to make that easier would help the industry. I will say, I wasn't directly involved in preparing comments on Stark, but I'm on the governing council with the health law section at the American Bar Association, and through the health law section, we did submit comments to CMS on that request for information about Stark. And seeing the comments that came out through the health law section, it's not that we're necessarily advocating for one direction or another in terms of where the regulations come out, but more trying to provide some background for CMS to understand, okay, if you make this change, this is the implication. And, the regulatory process can be very tough because it's not very reactive. Kind of as you said, the request for information came out last summer. Comments were due, I believe, like last September or October, and we're still waiting on a proposed rule to come out. So, the rulemaking process is definitely a retrospective review of things, and it's very hard for it to be very adaptable or prescient in terms of changes. So that kind of leads me to the last point about it, which is I hope that whatever changes are made are not so prescriptive that it makes it difficult to anticipate unanticipated changes within where the industry could be going.
Right. And now we're seeing also rulemakings proposed for HIPAA. And do you think it'll take a similar path?
So the HIPAA one, I have definitely a different perspective on it. And again, the health law section worked on comments for that. And this time I actually did help draft some of those comments. And frankly, I don't think HIPAA really needs that much changing. When you get down to what HIPAA does, it is already pretty flexible in terms of its approach to what it expects of organizations. When I'm talking with people about it, whether it's a client or on social media or anywhere anyone's willing to listen to me talk about HIPAA, I always like to say, the privacy side of it, yes, the rule there is pretty clear in terms of what it expects. When you look at the security side, it's actually very adaptable to each organization or each entity's specific circumstances. And when you get down into the weeds of what it actually says, it actually is not the full scope of what would be needed for good security. I always like to tell people that it provides a good foundation to build from, and it allows you to have that solid framework to build a really robust and industry best practice type of security program. But if all you were doing is all the minimum required by HIPAA, your organization probably isn't secure at all, and your data is gone before you know it.
Right.
So and that's why I say I think HIPAA doesn't really need that much changing. There's probably some tinkering here or there that could be done, but if you start trying to wholesale change it, I think you run the very real risk of all of a sudden trying to craft rules that apply to the current state of technology. But as we've seen, technology evolves at an extremely fast pace. And even with that tremendous speed of development, it still operates within a regulatory scheme that was, for the most part, developed in the early 2000s and premised on a law passed in 1996, before a lot of this stuff was even dreamed of. So, I think a lot of the calls to have major reforms don't necessarily fully appreciate how HIPAA really operates.
I would have to agree with that, definitely. Okay, so one issue that resonates through all of healthcare is the inability of regulation to keep up with innovation. One of CMS considerations is the need for modernized regulations to account for cybersecurity and electronic health records. What changes do you feel need to be made, or that we're actually going to see this year?
I'm not so sure too many changes are actually going to happen this year. I know we were talking about Stark. I think the latest I saw is that some type of proposed regulation will be out this summer on Stark. If say that comes out in like the July timeframe, by the time you have a proposed rule come out and the comment period, it would be sometime in 2020 before anything is finalized. The HIPAA side of things, like we were just talking about, haven't even heard any hint of when anything could be coming out. So again, the earliest anything that would happen there is probably in 2020. I think probably the biggest chance for action by one of the agencies is through some type of sub-regulatory guidance, which is really just any one of their guidance books that might come out, or statements in terms of expectations. So I think those frameworks and sub-regulatory statements are very helpful. One of the big things they do is they help people kind of understand the thinking of the agencies and some of the expected direction of where things would go. And probably one of the things I'd point out as great examples of that, we haven't had anything in the past couple of years, but a few years ago, ONC and OCR, so the Office of the National Coordinator and the Office for Civil Rights, collaborated quite a bit on putting out explanatory pieces of how to interpret HIPAA as it applies to digital health tools, web-based, cloud-based solutions. And from the legal perspective, when I read it, there was nothing new in there. There was a lot of re-recitation of long-standing commitments, but for people in those industries, the reaction was, wow, they finally thought about our industry and they thought about how this applies to us, which I think underscores what the biggest issue, which is that too many new companies, and I know you said in the innovation space, which is where I think new companies, startup, or people just trying to get into healthcare, they're trying to do all these things without understanding the industry that they're getting into. So when there's all this call for change, is it that change is actually needed, or is it that people who are asking for the change are just saying that because they don't want to have to take the time to understand what they're getting into?
Exactly, right. That makes sense. Okay, so what are your top 3 best practices for healthcare organizations who want to lessen the likelihood of being penalized for non-compliance issues?
Hopefully I can keep it down to 3 items.
I know. I thought about this one.
So I think the first and most important one is actually to think about compliance and to put appropriate policies and procedures in place to guide operations. A lot of the healthcare regulations and laws do call for policies to put in place. I'll pick on HIPAA as the most obvious example, where you cannot comply with HIPAA if you don't have your privacy rule, if you don't have your policies consistent with the privacy rule and the security rule into place. So that's one thing. Another big piece is to educate and train people within the organization. I think we were talking about earlier, which is how can you expect anyone to comply with something if they don't know what they're supposed to be complying with? And the way you do that is to educate and train them. So that education oftentimes or sometimes is only done upon an individual being hired, both under HIPAA guidance and under guidance when you're talking about general compliance guidance and general compliance best practices, is to have at least annual trainings and then to have regular reminders of different obligations and to be able to highlight the changing nature of potential threats. And then I think another one, which is maybe one that doesn't necessarily get as much attention, is to create a culture of compliance within an organization and encourage people to ask questions and to raise concerns if they are not certain about a particular proposal. So in the way, and I think one of the more effective ways to do that is to make sure it's coming from the top down and to not just say it, but to have everyone living and abiding by that type of a culture. So it can't just be words, but you have to back up the importance of compliance through action too.
That's so true. And I, often with providers, with like what you said about the training, it's like you create that kind of buy-in from your employees, if they know that there's a culture of compliance and that you're invested in them learning and relearning because I always feel like where they fail is the retraining of the staff. They just do it, like you said, that one time, and then they list off to the races, hoping that everybody complies. That's just interesting how, I think there's like a lack of investment in training.
Yes, no, I do recognize it takes away time from what's important to an organization, but I guess one response to that is yes, it's not quote productive time, but by corollary, if you can ensure that operations are being run in a manner that's consistent with legal requirements up front, you're going to save a lot more time than if an issue is found later on and you end up having to respond to an investigation that could lead to a potential fine, or if you're talking about a fraud and abuse issue, could lead to a whistleblower suit or some other type of enforcement action where you could be subject to very major penalties.
Mm-hmm.
So I think there's a lot to be said of if you pay attention to these obligations up front, it's going to save you time and money later on.
Exactly. Wow, that's a lot of information for us, Matt. Thank you so much. So let's take it down a notch. For our listeners who don't know you quite as well as I do, you're quite the celebrated individual in your local market. So tell our listeners what a super lawyer is and how you came to be heralded as one.
The super lawyer program is actually, I think, something that's national based. I think every market runs it, but it's to some degree a peer recognized distinctions because you have to be nominated by other lawyers, and then it goes through some type of a honestly black box vetting process. So I can't say I know how the selection happens, but it's ever since I've been lucky enough to have that distinction, you get a message saying, are there other people that you want to nominate? And at least personally, when I get that, I very thoughtfully try to go through the people who I've worked with on transactions or other things, and tend to be very selective in terms of the individual as well, suggest for consideration for the distinction. At the same time, I always take it with a little bit of a grain of salt because you never know how some of those things happen, but it is definitely an honor to be able to get it every year.
Wow. Okay, Matt, thank you so much for all the information you shared with us today. Now, where can our listeners find you around social media?
So like you, Shereese, I'm pretty active on Twitter. So my handle there is @Matt, that's Matt with 2 T's, _R_Fisher, and Fisher is just FISHER. You can find me on LinkedIn as well. You can also find me blogging. If you search Pulse by Myrick O'Connell, that's the blog that I do through my law firm. And then, I'm also, like you, a host of a show for HealthcareNOW Radio. So you can always look for my show, Healthcare de Jure, which just like this one, a new one comes up every 2 weeks.
Okay. I want to thank my guest, Matt Fisher, for joining me today. Check him out on social media. Thank you so much, Matt. This was so much fun. I'm so glad we got to spend this time together. We usually don't have this much time.
Yeah, no, thank you very much. You're right. It's nice to have a dedicated period of time to be able to chat.
Right. So I will look forward to seeing you around social media or around the conferences if possible. And thank you for tuning in today. For more information about Interviews Now, visit our show's program page on HealthcareNOWradio.com. And until next time, if it's happening in healthcare and it's now, it's on Interviews Now.